Well, good afternoon to everybody on the East Coast and good morning to everybody on the West. Thank you for joining me today. So throughout 2018, state, federal, and local legislators in the United States have been proactive in passing new labor laws to protect the rights of workers. And hence, there's been a lot of changes that have happened through 2018 and going into 2019. Um, Today, myself, John Burns, along with my esteemed colleagues on the Replicon's Global Compliance team, Sajid, Kalyani, and Shreya, will be going through what's changed in the United States and what you can expect in 2019. We're going to look at we're going to look at a few areas, including minimum wage, predictive scheduling. We'll talk about what's changed on the paid sick leave front, as well as discuss new planned and unplanned leave entitlements that have been enacted at the state level. After that, we will look at the most recent proposal from the Department of Labor and the impact it'll have on the salary level test. After that, we will conclude with some best practices and we'll talk about some additional resources that you can reference before we go into a Q&A. Just a couple of housekeeping points. So during the presentation, you'll be on mute, and Q&A will take place at the end of the webinar, but feel free to submit your questions anytime via the questions box. And with that, I'm going to turn it over to my colleague, Sajid, who will take us through minimum wage.
Thank you, John, and hello, everyone. I'll be taking you through minimum wage. Basically, first I'll talk about the history of minimum wage, why minimum wage was introduced. So in 1938, President Roosevelt signed the FLSA into law, in which it was mandatory that there should be a minimum wage. And the reason behind for that was that a person who is working should have a minimum standard of living for his health, efficiency, and general well-being. So from 1938 till now, there have been 6 revisions to the federal level minimum wage, from 25 cents to now it is at $7.25, which was last updated on July 24, 2009. Moving forward, I'll take you through the scenarios wherein minimum wage of a state might be lower than federal. So the 4 scenarios, classifications of minimum wage. When a state has minimum wage higher than federal, it becomes an obligation on the employer side to give them the state minimum wage and not the federal. And when the state and federal is at par, it is up to the employer to decide which one. So if they are both on the same $7.25, a state has to give that. And wherein a place wherein state does not have a minimum wage, it automatically goes to the federal. The employer's obligation has to becomes that he has to pay the employee at a federal level. In scenarios where state minimum wage is lower than federal, what happens? Automatically, it goes back to the federal. Let me give an example of a couple of states. Georgia and Wyoming, the federal minimum wage is at $5.15, but it's an employer's obligation and duty to pay their employees at $7.25 to avoid any lawsuits. New York being at the highest at $15 per hour. It is a double of what an employee used to earn 5 years ago. So they're revising their minimum wages quite frequently. And even before at a federal level, when the minimum wage was passed, Massachusetts passed their minimum state level wage law in 1912. And going forward, looking at the current minimum wage update for 2019, if you see the map, wherein the color is green, there is no change. Wherein there is a little change, that is a state increase, that's an amber. And purple is one where there is state and local increase. And the red ones are where there is no increase at all. Moving forward, what do we look forward in 2019 from the minimum wage perspective? So it's been nearly a decade when the federal level minimum wage was increased. So there is already a bill which has been proposed for $15 per hour for a federal level minimum wage, wherein there are 181 co-sponsors from the House of Representatives and 31 co-sponsors from the Senate. So We would be monitoring this if this comes out, and we would be publishing it on our website as well as an update when the law is passed. From the state side, we do regularly monitor the minimum wages. So, like, there is a bill for Hawaii, New Mexico, and Maryland to raise the minimum wage to $15 per hour. There was recently a bill which was narrowly defeated in Virginia, so they will go back to their old minimum wage. And moving forward, I'll hand it over to my colleague Kalyani. She'll be taking you through the predictive scheduling.
Thank you, Sajid. Hello, everyone. So I will be taking you through the predictive scheduling bit on how it has affected the US employment scenarios. A little bit of history on how predictive scheduling gained their fair share of importance in the United States. Unpredictable schedules and late notices for shift-based work has made it difficult for employees to plan their life outside work for the past few decades. And to add momentum to this, in around July 2017, Victoria's Secret agreed to pay around $12 million to resolve a class action lawsuit in California brought about by hourly employees who claimed that they were denied pay as a result of their retailer using on-call shift scheduling. And moreover, over the years, many other such employers have faced heat for similar circumstances, especially in the retail, hotel, and service industry. So what is predictive scheduling? Predictive scheduling, also known as secure scheduling, fair scheduling, or fair work week, is a set of obligations on employers to certain identified industries to post their schedules of employees in advance, which is usually between 7 to 14 days before the first scheduled shift, to give extra pay to employees if there is a last-minute change in the schedule, and to provide adequate rest period between shifts, and etc. It is important to note that as these laws are getting enforceable, violations by employers to adhere to any of these obligations pose heavy fines and other penalties as well. Moving forward, what we can see is a time frame or a timeline of how the predictive scheduling laws came into picture in the United States. Currently, as you can see, 6 cities and 1 state have passed some form of scheduling law. San Francisco was the first to enact scheduling regulations with its Formula Retail Employee Rights Ordinance in 2016, followed by Seattle, Emerville, California, New York, and at latest joining this bandwagon is Oregon. It's important to note here that many of the predictive scheduling laws which have been passed in 2017 and 18 are enforceable from 2019 onwards. This is basically to give the employer sufficient time to comply with these regulations. So moving on, we can look in detail the Oregon predictive scheduling law, because Oregon was the first to do a statewide predictive work scheduling law, which took effect in July 2018. Similar work scheduling bills have been introduced in several states, but Oregon's Fair Workweek Act is the first to become law. As you can see in here, the law requires the schedules of hourly employees in food service, hospitality, and retail employers with at least 500 employees to be more predictable. As such, like employers to give schedule of work at least 7 days in advance. And it's interesting to note here that it is by July 2020, this has already been revised as this advance notice period rises to 14 days. Any changes to such schedule outside the notice period require the employees to provide something called predictability pay to the affected employee as well. And taking precedence from Oregon, other states are also en route to passing such laws. Now we can look at what is expected in 2019 in this field. Is that Philadelphia has already entered this predictive scheduling mix with its newly signed Fair Workweek Employee Standards Ordinance, as it becomes effective only in January 1st, 2020. Connecticut and a couple of other states are currently reviewing the predictive scheduling laws as well. On the industry front, we can notice that Walmart has recently introduced an app called My Walmart Schedule that allow employees to see schedules, swap shift with coworkers, select unfilled shifts to work, etc. So while this is changing the workplace environment drastically, something to keep in mind while implementing predictive scheduling is the growth of different local predictive scheduling laws could provide challenging to employers given the different requirements across jurisdictions. For example, the same employers operating in Seattle and New York City may have to comply with different requirements, different notice period, different predictability pay, etc. But overall, if you see, these laws will protect the work-life balance and financial stability of employees through fair and advanced scheduling practices. And this is an effort in the right direction as it allows employees to plan their life outside work further in advance without worrying about scheduling inconsistencies. And ultimately, a happier and healthier workers result in improved performances and help reduce the cost of attrition. With this, I hand it over to John to take us through the paid sick leave changes that has happened across US in the past year.
Thank you, Kalyani. So when we look at paid sick leave refers to time off that's given to a worker to stay home due to illness or sickness. It accrues based off of hours worked, although it doesn't have to necessarily be given that way. But paid sick leave started out in San Francisco back in 2004, and what we saw a movement has now spread across the country. We have dozens of counties and cities that have enacted their own requirements, such as Cook County, Chicago, Montgomery County, Maryland, and other cities such as Philadelphia and Pittsburgh. Now, after the San Francisco enacted its ordinance, what we saw was that other local communities enacted their own set of requirements. Subsequently to that, then we saw states enacting their own legislation. Connecticut was the first state to require private sector employers to provide their employees with paid sick leave. That happened in 2011, and then shortly after, California passed the Healthy Workplace, Healthy Families Act of 2014. Subsequently, we saw that states like Massachusetts, Vermont, and Oregon passed their own requirements as well, mandating paid sick leave. Most recently, Michigan has a paid sick leave ordinance going into effect March 29th of this year. Now, there's two key points to take away from here. Is that if you are a business in a state that has both state-wide paid sick leave requirements and then also city and county requirements, you need to look at the requirements at the local level, right? Because what happens here is often the local level will have even more stringent requirements than the actual state. For multi-state employers, you need to look at the different laws in each state because they are starkly different. If we look at California versus Michigan, for example, we can see that in California, essentially the definition of an employee, first off, is very broad. It includes part-time employees, per diem, and temporary. And any employee that is working in the state for 30 days or more within a 12-month period is going to be eligible for paid sick leave. Now, some of the exclusions mentioned include certain workers in the construction industry or who work on air carriers, and certain employees that are covered by a collective bargaining agreement. Now, just because you're covered by a collective bargaining agreement doesn't automatically mean that you're not entitled to paid sick leave because there are requirements for the contract to have such in there. In terms of accrual, we have 1 hour of leave accrues for every 30 hours worked. Now, if you have employees that are working full-time, right, you would use 40 hours as the basis of the calculation. But now if we jump over to, let's say, Michigan, and we look at what's required, what's the details of their paid sick leave law, right? Coverage includes private employers and state and local governments with at least 50 or more employees. But the key distinction here is to look at is the exclusions. Uh, it's it's it leaves you wondering who is included, because there's so many employees that are listed as being excluded from the law. This includes employees that are exempt from overtime requirements under the Fair Labor Standards Act, as well as private sector employees that are covered by a collective bargaining agreement. In addition, temporary workers, independent contractors, variable hour employees are also excluded. Certain part-time and seasonal employees that were found to have worked 25 hours or less on average per week in the previous year are also excluded. And the accrual is going to be not as generous as California comparatively, right? Where 1 hour of leave is going to accrue for every 35 hours worked. So the key message here is to pay attention to the details, know what paid sick leave laws and ordinances apply to your business, and know what the accrual requirements are and which employees are subject versus not. Going forward into 2019, there are a couple of areas that'll be trending as it relates to paid sick leave. So we'll continue to see more cities and states consider mandating paid sick leave requirements, Maine being the most recent. But more interestingly, I'd say is to look out for states that will be considering that are looking to restrict the local authorities' ability to require paid sick leave, such as in the case of Texas. And finally, we'll also see more private employers continuing to consider offering their employees paid sick leave benefits voluntarily. The most recent example would be Walmart, who is now offering employees paid time off for use for sick and other illnesses. In terms of paid sick leave update or ordinances or laws that are taking into effect in 2019, right now Westchester County, New York is going to be the latest after Michigan to have their paid sick leave requirements go into effect starting April 10th of this year. San Antonio right now has a paid sick leave ordinance that's scheduled to take effect on August 1st, but we do need to pay attention to what is happening at the state level in Texas. So if the state legislature enacts a law that basically restricts the local authorities' ability to enact a paid sick leave ordinance, we could see something happen with San Antonio not going into effect. But right now, expect that on August 1st, it will take effect. And finally, Duluth, Minnesota will have a paid sick leave ordinance starting January 1st of 2020. So employers that are residing within those parameters of the county or city would be subject to those requirements. And with that, I will turn it over to Shreya, who's going to talk to us about new special leave entitlements that have taken into effect or will be.
Thank you, John, and good morning, everyone. I would be taking you through what special leaves are, the kind of special leaves introduced and in 2019, and what we are going to see beyond that. Special leaves are basically an arrangement between employer and employee wherein the employee requires time off for various reasons. There are two kinds of special leaves: planned leaves, which are leaves requested in advance by the employee, and the same request is accepted in advance. An example for this would be maternity leave. Unplanned leave, on the other hand, is a type of leave which identifies the need for absence by reasons of unforeseen or unexpected circumstances. Uh, for example, emergency responder leave. Going further on to the next slide, in 2018, various states came up with new leaves. Illinois introduced emergency responder leave, under which, during any kind of emergency, for example, a fire, an employee who is part of an emergency response team can take the day off or arrive late at work and cannot be terminated for the same. Massachusetts in 2019 introduced parental leave and school activity leave, under which an employee is entitled to 8 weeks of unpaid parental leave for birth or adoption of a child. In case of school activity leave, an employee can take a few hours or a day off to attend any kind of school activity for his or her child. Nevada in 2018 introduced domestic violence leave, which provides 4 weeks of unpaid leave to employers who are victim of sexual assault, stalking, or any kind of sexual violence. In 2018, again, New York came up with paid family leave, which provides the employee up to 8 weeks of paid leave to take care of newborn, adopted child, or to take care of family members who are seriously ill. Amendments to these leaves happen time and again, and New York is the one of the examples for it, where in January 2019 the state increased the duration of paid family leave from 8 weeks to 10 weeks. The eligibility and the reasons for leave remained the same. In 2019 and further, we will see a few leaves introduced in various states. District of Columbia has introduced Paid Leave Act, which is going to be effective from July 2019, providing 8 weeks of parental leave to bond with a child, 6 weeks of family leave to take care of ill family members with health conditions, and 2 weeks of medical leave to take care of their own serious health conditions. Washington in 2020 will introduce family and medical leave. This leave may not exceed 12 times the typical work week hour during the period of 52 consecutive calendar weeks. Massachusetts in 2021 will introduce a paid family leave, which provides 12 weeks of family leave in a benefit year and 26 weeks in a benefit year of medical leave. The reasons for using these leaves are almost similar. Basically, it's birth of a child or adoption or foster care, health condition of a family member or their own health condition. And so, all in all, I would say that the special leaves in the United States are many in number and they will keep changing from time to time. We expect more upcoming changes further down in 2019. Now, John will take you through the overtime proposal changes that have that are coming up.
Thank you, Shreya. So last Friday on March 7th, we saw that the Department of Labor published their proposed rule update to the salary level test. And before we kind of dive into that, let's kind of lay some groundwork here. So we'll refer to two terms often in this section: exempt employees and non-exempt. So exempt employees are employees that are not required to be provided with overtime for working more than 40 hours in the work week. The primary advantage to having exempt employees is that you don't have to track their hours accordingly, versus with non-exempt employees who are entitled to overtime pay for working more than 40 hours in their work week. These employees need to have their hours tracked. Now, we saw that, as I said, on March 7th, that the Department of Labor announced the proposed rule that would update the salary level test. Now, the salary level test is a component of the analysis that needs to be done for determining whether an employee is exempt from overtime. And that analysis requires three parts. There's the salary basis test, which looks to see whether the employee is paid a predetermined salary or a fixed amount, and that salary cannot be subject to reduction for variations in work or quantity because of work quality or quantity. There's the salary level test, which is what the proposal is going to impact, and that specifies the minimum amount that must be paid to an employee in order to be considered exempt from overtime. And finally, there's the duties test, which looks at the specific duties as defined by the regulations and whether or not they're executive, administrative, or professional in nature. So all three of these tests have to be satisfied in order for a worker to be considered exempt from overtime. And under the existing salary level test, which hasn't been updated since 2004, by the way, an employee with a salary below $455 per week, which translates into $23,660 annually, must be paid overtime if they work more than 40 hours per week. This essentially means that they're considered to be non-exempt from overtime. So the latest proposal is going to boost that salary level to $679 per week. Okay, that's the equivalent to $35,308 annually. And if you have an employee that's being compensated above this salary level, then the eligibility for overtime will then be based off of the job duties and whether or not they meet the requirements for exemption under such. Now, one key difference between what was proposed last Friday versus what was proposed by the Obama administration. So if you recall that when the Obama administration originally proposed the increase to the salary threshold, which was originally $47,476, right? That proposal had an automatic increase in it, right? Where that's the salary threshold would have increased accordingly and automatically. With the latest proposal that's been published, the updates will not be automatic, but the threshold would be reevaluated every 4 years. So what to expect next? So right now, the Department of Labor has published the rule, and for the next within the next 60 days, comments will be due. And then after that, the department will reevaluate the comments and make any updates accordingly. In between, if everything goes expected and there's no core challenges, you can expect the salary level test to take effect in January 1st of 2020. And again, if it does take effect without any challenge, right, the key takeaways are it's going to raise that salary threshold, right? It's not going to change the duties test, and there's going to be no automatic increase. Going forward, in general, some best practice recommendations that we have. If you, in terms of minimum wage, make sure you understand the federal, state, and local minimum wage rules that apply to your employees, and make sure that you're complying with any changes that are taking effect. Make sure that all applicable minimum wage notices are posted in your workplace. And for if you have a shift employees, then we're a lot of employees that are working varying hours. You can use the scheduling platform to get a hold and get ahead of your scheduling. This is especially helpful if you are in Oregon or any state or city, I should say, like Seattle, right, where that has paid sick leave provisions or predictive scheduling provisions. If you are a multi-state employer, you should be aware of the local paid sick leave requirements and state planned and unplanned leave entitlements that apply to your employees. If you have a workplace in a location that has both state and local paid sick leave laws or ordinances that apply, make sure that you're applying the requirements that are most beneficial to the employee. And finally, some resources. So in Replicon, we have our compliance dashboard. This will tell you all of the different payrolls that are being used in your instance. The benefit to this is that this dashboard lets you easily track changes as they occur. When Replicon updates a payroll as a result of any changes in compliance, an update or notification will be flagged for you to review it in the dashboard, and that will give you an end-to-end understanding of what's changed. In addition, we have compliance.replicon.com. This is our global compliance database that gives you end-to-end information on all of the different states and the details. You can get information on the working time requirements, the overtime. You'll get very detailed information on the special leave entitlements that will apply for that particular state. So again, it's compliance.replicon.com.